Well, we're going to talk about something in the legal arena that I spoke with John about, and not just firearms, by the way. Balance Dylan and Gatsky does a fantastic job with land use type issues as well. They're a really, really great law firm, and we're real proud to have them on board with San Diego County Gun Owners. But what we wanted to talk about is a positive decision coming down from the Ninth Circuit Court of Appeals that you guys. Yeah, I know, right?
What did you say?
But don't get lazy. Don't get lazy.
Yeah, a positive decision. However, I'm hearing there's a lot of kind of misinformation. People are making it out to be a little bit more than it is. It's so rare that the Ninth Circuit gives gun owners a win that I think people are a little overboard on it. Yeah, so here's what happened. So we're going to talk about it. We're going to talk about exactly what actually happened. Proposition 63 was passed by the voters. And what that did, this is, a couple years ago, what that did is it enacted a possession ban on normal capacity magazines that hold more than 10 rounds. So for years, there's been a ban on the import or sale or purchase of normal capacity magazines. All your magazines, as everybody knows, has to be 10 rounds or less in California for you to purchase them or for you to sell them or for you to bring them into California. It has to be 10 or less. But Prop 63 actually made the possession of magazines that hold more than 10 rounds a crime. And that means that, people that have magazines since, before 2000, who are using them legally, it's legal to possess them. They can have them and use them and, just like regular magazines. But, again, you can't purchase them. So this ban would actually make just the possession of them illegal. So what happened was a local lady, her name is Virginia Duncan, and she is the plaintiff, and they took them to court and said, hey, we're going to sue. We don't think this law is constitutional. But before we even get to court, we want to make sure there's an injunction on the law, meaning that they cannot enforce the law yet. So they basically said, hey, we want our day in court before this law is enforced. So the judge listened to the case and said, yep, there should be an injunction. This is definitely going to court. Now that right there is an important step. On the exact same day, another plaintiff went to court with the exact same argument on the exact same law, and the judge kicked him out. Said, nope, you don't have a case. So they actually had to decide, yep, you have a case, and we're going to do an injunction. You've made a solid case on this. So the state of California fought the injunction before they even got to court. They said, well, we don't even think they should have an injunction. This is ridiculous. They shouldn't even have an injunction. Now, why that's important is, let's say you have magazines that are over 10 rounds, a normal 30-round magazine for an AR or a
15 for a Glock.
15 for a Glock, yeah. These are not exotic, magazines. These are normal capacity magazines. Let's say you have one from, pre-2000, and you're using it legally, and you're possessing it legally. If they lost the injunction and they said, oh, no, we're going to enforce this law right now, then you'd have to get rid of those magazines. You'd have to get rid of your normal capacity magazines. Now, let's say that they went, the court case was successful, and they said, oh, you know what? A magazine ban is unconstitutional. Well, there's no way to get those back into the state because there's already an import law. So it was crucial that this thing wasn't just like it'd be nice to have the injunction, and boy, that'll keep it, legal a little bit longer. No, this was crucial to people who had a normal capacity magazine in California, because if they didn't get the injunction, or if the injunction was overturned, you'd have to get rid of your magazines. And even if we won the court case, we lost the fight. So, the decision was to uphold the injunction, but it still has to go to court. They still have to have a ruling, and then appeals have to be exhausted before we have a real victory.
Right. So it is going back to court, going back to trial. And from what I understand, it's not because it was voted in. Because it was voted in under the Safety for All Act on Proposition 63 that was on the ballot. The fact that it was voted in doesn't make it unconstitutional. Is that correct?
Well, no, because when it's voted in on proposition, the only way to get rid of it is either have it struck down in court or another voter initiative. Okay. So what can't happen is the voters can't, like let's say the voters have another proposition and it's in place. The legislature can't undo what the voters did directly.
Okay.
So that's that makes it cements it in really until you have another voter initiative. But yeah, just because the voters vote for something doesn't mean it's constitutional. I mean,
Thank God.
Slavery down in the South, the voters all wanted slavery down in the South, but of course that was unconstitutional.
Right.
So you can, the voters can vote for something unconstitutional.
Okay. All right. So now my other question is, some understanding was the reason it is unconstitutional is because of the fact that the government, state, local, or federal, cannot make a citizen give up personal property without some sort of compensation.
Well, that's the argument. That's exactly the argument. And it's important to understand, too, that the 3-judge panel was not ruling. It wasn't really a gun case. It was, but it wasn't. What they were ruling on was, hey, did this judge, by putting the injunction in place, did he abuse his power? Right.
That's what they had to come down and say, did he abuse his power or not? And they said, okay, he did not, and that's why it upheld.
Yeah. So it's.
So the 9th District did not give gun owners any love. They they could only.
They couldn't figure out how not to.
Well, exactly. Yeah. They could only judge on that one parameter.
Yeah. Don't get too excited about the Ninth Circuit didn't have some huge epiphany and change of heart.
They're all out in a bar getting drunk right now because they couldn't do it. That's what they're doing.
Yeah, it was a 3-judge panel, and it still was 2-1. It still wasn't a 3-0 decision on this 3-judge panel. So one judge on the 9th Circuit Court of Appeals decided that this judge, by putting an injunction on this, was abusing his power. I mean, it's just absolutely ridiculous. They're such extremists. Right. Talk about
anybody can be accused of abusing their power. It'd be the 9th District.
That is a true story. We need to abolish, not abolish, but we need to get the 12th District.
New people in there. But anyway,
so
talk about
I digress.
Judge activism and legislating from the bench. I mean, but the important thing is to know if you have magazines that are over 10 rounds, possession of them right now is not being enforced. Okay, so they're going to hear the discussion. There will be a ruling, and once there's a ruling, man, you're going to hear it from everybody. But still keep an eye on it. But right now, the magazine, the possession ban is not being enforced.
All right,
cool. So,
all right, we're going to take a break there,
right,
Sunshine.
I got a question when we get back.
You ain't going to be able to remember unless you write it down.
Without someone doing something about it, it's not going to get any better.